Thank you, Dr. Shafina. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu ala Rasulillah wa ala alihi washabbihi ajma'in. Assalamualaikum warahmatullahi wabarakatuh. Respected members of the audience and also dignitaries and students, I would like to thank the faculty, the Kulliyyah, for inviting me to give this view on a very important topic and a difficult topic actually. For me, I've left constitutional law for a long period of time, actually since maybe 10 years ago. But Alhamdulillah, recently I've been asked to teach constitutional law, so all came back, Alhamdulillah. And many of here are my students, I think, both at the undergraduate and postgraduate level. So I'm not repeating the lecture that I've given you actually. I've prepared slides for this one, Alhamdulillah. And there are many slides, but definitely I'm not going to refer to all the slides. Otherwise, it will take more than 1 hour. But after listening to the two prominent speakers earlier, the two keynote addressees, yang Ahmad berhormat Abu Menteri Besar, and also the Tun Hamid, I think we are probably receive a different view as to whether the basic structure doctrine is viable or not in the light of our constitutions. But because I already prepared the slides, might as well look at some of the views on this issue. Okay, can we see first? The first slide is on the judicial oath. As per the Constitution, in the schedule of the Constitution, you can see that the emphasis, which I've already emphasized in red, that the judges will preserve, protect, and defend the constitutions. As Mr. Arun has already mentioned the oath earlier, in fact he went further to mention also the oath of members of Parliament. But I will confine to just the judiciary for my speech today. Next, please. Now, when we talk about rule of law, I mean, Ahmad berhormat Datuk Seri Adnan mentioned about Daisy is pronounced as Daichi or Daisy, but I think most of us pronounce Daisy, right? For those who are the constitutional law students in the first semester, I mean, at least in this university, they will be studying about the rule of law, and they will have to know Daisy by heart, right? So what Daisy said, there are 3 important principles which Daisy said. That is, whenever we have law, then only the law can actually punish a person. Meaning to say that no man is punishable except for a distinct breach of the law. Secondly, that we have equality principles. And thirdly, of course, the courts play an important role in upholding the rule of law. Now, these 3 important principles that Daisy have laid down in his book when he was studying the English law, the English constitutional law at the time, had not taken into account many issues, in fact many practices. Now he was fond of the practice of the French, the droit administratif, if you still remember your constitutional law. Okay, can we go to the next slide, please? Now, these are the critics of Daisy. Now many have written, even at the time when Daisy was publishing his book. Now, many had written to criticize Daisy's principle. I've got some of these views about Daisy's principle of rule of law. For example, Sir Ivor Jennings, of course, another well-known, constitutional law commentators. He said that the principal rule of law of Daisy has not taken into account that there are many discretionary powers that are given to the executive. That's number one. And there's also Friedman who wrote recently that the notion of government is that there is no equality between the government and the citizen. Isn't it? Because the government is to govern the citizen, then how can there be equality? And there are also many other critics. If you go through the critics of Dicey, there's so many of them, right? But yet, can we go to the next slide, please? But yet, we, in any states with constitution, whether written or unwritten, there are only 3 countries in this world have unwritten constitution, right? I always ask this to my students. Besides UK, what are the countries? What are the countries? New Zealand and Israel, right? So, yet, rule of law is important. But rule of law has to be adapted to modern circumstances. So that's what happened to Lord Bingham, former Lord Justice of the UK courts. Now, he came out with very interesting sub-rules of law. Okay, there are 8 of them. So if I can go very quickly. Number 1, that law should not be so vague. Secondly, legal rights and liabilities must ordinarily be resolved by the application of law and not by the exercise of discretion. Okay, so he emphasized of legal rights and liabilities. He does not reject discretion, but when it comes to legal rights and liabilities, it has to be decided by law, but not by discretion. Thirdly, he mentioned about equality is good, but yet we should also allow rational classification or differentiations of treatment. And of course, number 4, he said about fundamental liberties and protection of human rights. And number 5, number 6, and so on. Okay? So this restatement or reconstruction of rule of law is important. And in 2009, the International Bar Association had come up with their own sub-rules of the rule of law, okay, which emphasize on, for example, can you go to the next slide? Yeah, this one, right? The existence of an independent judiciary, the impartial judiciary, the presumption of innocence in case of criminal accusation, the prerequisite of fair and public trials, the observance of a rational and disproportionate approach to punishment, the existence of strong and independent legal profession. Next. Okay? The strict protection of professional secrecy, the maintenance of equality or fall before the law, the absence of arbitrary arrest and secret trial, the absence of indefinite detention without trial, the exclusion of cruel and degrading treatment of punishment, the absence of intimidation, the conduct of governance in society, and so on and so forth. 12 altogether. So, well, with this restatement and reconstruction of rule of law, we are, I believe, in the same state of affairs, in the safe state of affairs. So we are in the right direction, and in the reflections of the rule of law principle in our constitution, next please, we have the principle of supremacy of law as per the constitution. It says that punishment that can be imposed must be based on the law that exists. We have the principle of supremacy of the Constitution in Clause 1 of Article 4. We have Article 7 that prohibit retrospective criminal law and repeated trials. Next, please. The second principle of the rule of law by Dicey, we have Article 8, of course, with some exceptions, many exceptions in fact. Okay, and the third principle of rule of law, we can see that Article 4, the supremacy clause, we have Article 4, Clause 3 and 4 that give the courts the power to review law made by Parliament and made by state legislature. We have the powers of the court as per Article 121, right? Despite it being taken away, the judicial power is Article 121, but the recent case of Indira Gandhi, the court re-emphasized the importance of judicial power despite the provision of judicial power has been taken away by the amendment to Article 121. And of course, Article 128, which gives the federal court the power to declare law to be unconstitutional, law made by Parliament or law made by the state legislature. Right, so that is rule of law, because my topic covers two aspects, that is the judiciary with the rule of law and the judiciary with the supremacy of the Constitution. That is the constitutional supremacy. As we have seen in Lloyd Kui Chun, the emphasis of constitutional supremacy is basically three. Number one, that the fundamental rights which the state cannot encroach, where it is not allowed to encroach. That's number one. Number two, the distribution of powers between the states and the federation, or the federal principle that we have maintained so far. And secondly, the separation of power between the executive, the legislature, and the judiciary. Thus, so in order for the supremacy principle to be upheld, right? Raja Azlan Shah, who was one of the judges in Law Koi Chun, has said that, however, the statement that is in Article 4, Clause 1 is somehow or rather redundant. On the ground that, how can a law that says is supreme, say it in itself, right? So that is what he said. But anyway, Raja Azlan Shah in Law Koi Chun has insisted that when there is amendment to the Constitution, it is valid as long as Article 159 and Article 161 are followed. I think Ahmad Datuk Seri has mentioned this earlier, and also to Hamid just now. And the court has power to invalidate any law that is passed which is unconstitutional, and also law passed after Merdeka Day which is against the Constitution shall be void. So in that respect, the word law refers to law made by Parliament, okay, but does not include constitutional amendment law. That was what Law Koi Chun was insisting on, okay. And of course, the other one which is still very controversial today is the presumption of validity. That law made by Parliament is valid unless proven invalid in the court of law, right? Of course, I will not go into that issue because it's not the scope of this paper. So then we have this doctrine of basic structure, which I will not repeat what had been said earlier by two our prominent speakers, right? But basically, Law Koi Chun decision was frowned about insisting of the existence of such doctrine on the ground that otherwise then the court would usurp into the powers of Parliament. The court is not given the mandate to make law. So the court should not be making law when Parliament is the exclusive authority to make law. That is the basis of the rejection of the doctrine of basic structure in Law Koi Chun. But of course, earlier, there was already an arbiter, okay, mentioned in the case of Government of State of Kelantan and the Government of the Federation of Malaya and Tunku Abdul Rahman, where Thomson CJ said that unless the change made by Parliament in the Constitution is so fundamentally revolutionary as to acquire fulfillment of a condition which the Constitution itself does not prescribe. So some seed was already sown on the basic structure doctrine in earlier, but of course rejected, clearly rejected in Law Koi Chun. And of course later on, next please, Pang Chin Hock also rejected this doctrine when Sufyan LP was saying that we cannot follow the Indian Supreme Courts because the basis of the Supreme Court of India judgment was based on their constitution, which was drafted by their constituent assembly, and that the Indian constitution has a preamble and a directive principle that they can rely upon, that we do not have. The Constitution of Malaysia does not have a preamble, and we do not have a statement of principle. So in that respect, we cannot rely on the Supreme Court in India on this issue of basic structure doctrine. Right. Can we go to the next slide, please? Another one? Yes. So the departure had started, of course, as mentioned earlier, in Semenya Jaya Sdn Bhd, and later on cases of Siwa Rasa. Okay, next slide, please. And most recently, 2018, reported in January Next please. Yes, this one, Indira Gandhi, right? On the basis that the fundamental underlying principles and the role of the judiciary form the part of the basic structure of the Constitution, being something fundamental and essential to the political system. Now, of course, many has been said, and I will not go into repeat those. And what can we conclude? Next slide, please, on this issue of basic structure. At least there are two principles of structure that have been identified in Semuanya Jaya case. First, the doctrine of separation of power, and secondly, the independence of the judiciary. And of course, in Sivarasa, the fundamental rights provision in Part 2 of the Federal Constitutions, and in Indira Gandhi, the issue of judicial power and the power of judicial review. So, what next? What else? Of course, when we look at the Supreme Court decision of India, it mentioned about the basic structure to be decided based on case-to-case basis. So we have 3 cases, and they have laid down at least 3 basic structure. What else, like what I was saying? So this would definitely left to the courts to decide, right? So if, of course, the courts later on would continue to accept the principles of basic structure as per decided by the 3 cases of the federal court. But of course, what we have heard this morning was an argument to the contrary. So as law students, I believe that it would be allowed to evaluate both views and then decide. Decide not based on emotion, rather to decide based on the total constructions of the constitutions. Okay, now on the doctrine of supremacy of the Constitution, can we go to next? Yes. I've referred to Andrew Harding. Now, Andrew Harding has written a lot about Malaysian Constitution. One of these important books that has been published in 2006, which I referred to. Harding was referring to this issue of people making comparison about constitutional supremacy and parliamentary supremacy, which he said that one cannot confuse. Even the student of constitutional law sometimes confused the difference between constitutional supremacy and parliamentary supremacy. But leaving that aside, Harding was saying that there are factors actually can affect constitutional supremacy. Now he mentioned at least 5 factors. That is basically, he was referring to whether the party in power has a 2/3 majority or not in parliament. Okay, if the parties in power have a 2/3 majority in parliament, like what Dr. Sri had mentioned this morning, that the ability to amend the constitution would be much easier compared to a party that does not have a 2/3 majority. That's number 1. Number 2, 2012 saw the repeal of many emergency laws. I think this is very significant. The idea of transformation by the Yang Maha Perdana Menteri had shown an important aspects of recognition of rights. Okay, the repeal of ISA after that. Okay, the repeal after that also of Section 27 of the Police Act, and the promulgation of the PAA, Peaceful Assembly Acts 2012. And of course, we have seen also many other changes that would show an important improvement to fundamental liberties and the upholding of the fundamental rights under the Constitution. Now, the third point is that whenever a Constitution is amended, I think Arun has mentioned earlier that the feeling is that when you amend the Constitution, it's not just amending an ordinary law. Amending the Constitution is actually amending important principles of the Constitution, such as fundamental rights, states' rights, rule of law, separation of powers, and also it is not just from the point of view of politics. it has constitutional value in those amendments. Right? So I think Arun correctly mentioned about the need for parliamentarians to understand that whenever they are agreeing to the amending of the constitution, they would be actually going to give effect to the total structure of the constitutions. Okay, that's number 3. Number 4, whenever the principle of constitutional supremacy is upheld, then members of parliament should be aware that whenever the law is unconstitutional, then it would not see the light of the day. Even if it sees the light of the day, it will be next to be declared unconstitutional by the court. Okay? Now, of course, Harding also mentioned about legal supremacy or sovereignty must not be confused with political supremacy or sovereignty. Okay? So even if a political party has a 2/3 majority in parliament, they would not be the supreme authority because still the constitution is supreme. Okay, now on the issue of, can we go to the next slide please, the issue of the courts, the constitutional supremacy and the rule of law, I would like to refer to Shad Salim Faruqi's statement on this. And of course we know that Shad had been writing a lot on about the constitution, the rule of law, the supremacy of the constitution, separation of powers, fundamental rights in his weekly column in the Star. And I've referred to one of those writings. He was in fact emphasizing that the need to have the principle of constitutionalism imbued to every citizen of the country. But of course he accepted the fact that constitutionalism takes years or decades to develop root. So it's not easy to have that realization, the importance of constitutionalism or limited government. So Shad has made it very clear that we live in a country which is built around the rule of law, the separation of power, the supremacy of the constitution, and the independence of judiciary. And this has been intact, alhamdulillah. But of course there are there are loopholes here and there, but alhamdulillah, I think more than 60 years of independence, I think we are able to live within that framework peacefully. Now he mentioned about the provision of fundamental liberties that has been preserved, has been protected by the courts and also by the government to the extent of what is allowed in the provision of fundamental liberties. Of course, fundamental liberties that we have in Part 2 of the Constitution is not absolute, because they are already conditions, they are exceptions, which I think the law has been in line with that. And he mentioned about the army and the police are not on their own, they are under civilian control. I think this is significant. Now, he mentioned about changes made since 2012, the repeal of emergency law, the repeal of the Internal Security Act 1960, the repeal of Section 27, the amendment to the Printing Presses Publication Act, and many more, right? And of course the establishment of Suruhanjaya Hak Asasi Malaysia, Suhakam, which I think is also very significant for Malaysia. Now, I also have a liberty to refer to other writers, and a well-known former Lord Justice, Michael Kirby, who came to Malaysia many times and gave speeches. Can we go to the next one? Yeah, this one. Now, he was referring to the rule of law in his speech, in one of the speeches in 2000, I think 2002 or 2003. Now, he made this statement about the rule of law, where adherence to the rule of law alone is not enough. Because rule of law must comply with substantive human rights values. That's number one. Number two, rule of law should honor and promote individual freedom. I think this is something that goes beyond what the rule of law has. Okay, next please. Now he went on to say that whenever this question being raised about whether the court should be active or judicial activism. I think Dr. Sri had mentioned about judicial activism this morning. And he warned this, that the courts can be accused of being the tool of the government if they just read the law as it is. That was his warning. But then he also raised another warning to it, that then should the court interpret the law creatively, that is to promote judicial activism or not, right? So should the court use literal interpretation or use other form of interpretation that expand the meaning of the words in the law, right? So we have seen this in this country. We have seen judicial activism as per the doctrine of basic structure just now. We have seen judicial activism elsewhere in other issues that has been raised in the courts. Next please. The next please. Now, but then of course, there are cases that, or there are issues of fundamental rights which I think require some judicial activism. Now, I was referring to Ong Ah Chuan, okay, the Singapore Supreme Court decisions on the meaning of law, because law is literally means law made by Parliament, but the law interpreted by Article 160 does not mention those extrinsic values or extrinsic elements of, say, natural justice, principle of morality, and so on and so forth. But Ong Ah Chuan said in the decision reported 1981 that part of the system or part of the history of common law has accepted that law should incorporate the principle of natural justice. What is natural justice? Right to be heard and rules against bias, and of course not just that, the principle of fairness, which I think has been insisted by the court in Ong Ah Chuan. But in Malaysia, in Cik Ani bin Cik Itam case, even though the court agree that this should be the case, that law should be interpreted incorporating the principle of natural justice, morality, fairness, but then the court was saying that, well, the law that was in question, FIPA, the Firearms Increased Penalty Act, which imposed mandatory life sentence, was not arbitrary, fanciful, or oppressive. So in other words, the court is willing to go beyond the words of the law, provided that it is suitable to do so. Right? Now, next please. But in Beatrice Fernandez, interpreting Article 8, everyone knows about what happened to Beatrice Fernandez, right? Because she was said to be discriminated as a member of the Malaysian airline system simply because she was pregnant and therefore she had to resign. But that requirement of resignation was already incorporated in the collective agreement agreed upon between the union that she belonged to and also the employer. So when it was raised that this is discriminatory as contrary to Article 8, the court said, no, it is not. Why? Because Article 8 does not mention about private agreements. Because Article 8 mentions about law and executive decision made that is discriminatory. But if it is a private agreement, like collective agreement, then it would not be discriminatory. So again, of course, there's a lot of criticism about the judgment. Then again, how one would argue that the court was not unreasonable in the interpretation of Clause 8? Because it's already stated clearly in Clause 8, isn't it? But then again, why can't the court also incorporate the principle of fairness and this issue of interpretation of equality principles? So, so what I want to stress here is that it is not right to say that the court is always literalistic in its approach, because there are cases that where the court used the principle of natural justice, and in some cases as well, the court tend to be literalist in its approach. Okay? Now, I still have 5 minutes. Let me just go through, because there are other, we should allow more questions. Okay, let me just go through. Can we just go to other slide, please? Can we go further down? Okay. Okay, problem. Can we go back a bit? Go back. Problem with rule of law. I think when we have rule of law, there are problems of applications. I mean, the court is aware of this, but sometimes the court's hand is tied. Okay, so it has to be left to the legislature to then look into law that may be restrictive, maybe against the fundamental of, against the rules, the human rights, or it may be contrary to the principle of fairness, the principle of natural justice. So there's a need to see that justice to be done, of course. And when it comes to law, the application of the law should be fair. Secondly, whenever we have strict observance of the law, then sometimes it will not guarantee just and fair society, because law is not just one instrument. There are many others. The economics, the economy, the social issues, all these should come about as well as to help to ensure fairness. There are next please, wide discretionary powers that we have given the executive under the law. I think this should need to be looked into. We have the need to consider law from the point of view of internal security and defense. Of course, SOSMA, POTA, POCA, these are new laws, right? That take over the so-called strict rules in ISA, but yet it is justified because of the need of security and defense. Next, please. Public policy and public goals are there necessary to ensure the achievement of fairness, equality, that the below 40s are supported in many aspects. So there's a need to look into this. Right? Then of course we also have vast power of the government. Next, please. Immunity and privileges are given to certain sectors of the society. It is necessary, but then again, it may be contrary to the principle of rule of law. Next, please. The infringement of natural justice principle, which I think can be improved further. There are good decisions of Hong Kong equipment, of course, from the point of view of rights. I think reasoned decisions is good for us to have whenever a government is making decisions against us and affects our life. But then again, sometimes that decision or the reason of the decision need not be given in certain cases. I think it is rightly decided by Suguma Balakrishnan by the federal court that it's not in all cases that the executive should give reason for their decisions. Alright, so next please. And there are practical impediments to the supremacy of the law, the rule of the law as well, because there are many things that is still not fair. I think access to justice still a problem for us because legal aid is still very weak in Malaysia, unlike many other countries. Now we are only representing the people, those who are charged in criminal when it comes to mitigation, but not from the beginning. Of course, there are situations where the legal aid department would allow some assistance, but then some of these legal assistants, they are young and new, they do not have the experience yet, so yet they have to defend a person who has been charged in very serious cases. Now, let me just go to the conclusions. Let me go to the conclusions. I just want to share with you, this is from Michael Kirby's paper. Now, he was referring to Ronald Dworkin books. Okay, when Ronald Dworkin was writing a book on justice in Europe, he said, when there was this anecdotal situation where US Supreme Court Justice Oliver Wendell Holmes, who on his way to the court was greeted by another lawyer who said, "Do justice, justice." Justice Holmes replied, "I am not here to do justice, but to decide cases according to the rules." So that perhaps reflects the whole issue that we have today. Okay, that reflects the whole issue of the dilemma, if I would say the word dilemma, among the judges, that whether they interpret the law as it is, literally, or they should incorporate the principle of natural justice, fairness, and morality into the law, where the law is silent about this. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Firstly, our panelists, and then the best here with the presence of not only the person who sponsored the session, but also a very knowledgeable member of state legislature, and of course the members of Ahmad, that is Yang Ahmad and the Secretariat, and then I would like also to welcome Yang Ahmad Ibrahim, that is the Chief Judicial Court of Selangor, as well as our beloved Dean, Dr. Professor Dr. Ashkar Ali, and the members of the panelists, Professor Dr. Kamal and Mr. Abdul Qasim. So I would like to take much time because I believe that a lot of members of the audience have would like to pose or ask questions to members of the panelists, and we have I think around 30 minutes. Maybe I can have perhaps 3 to 5 questions in the first round, and then followed by the second round if we still have the time. Okay, so
that is a self-serving legislation. So I would say that if you are touching on the basic structure, if someone is touching on the basic structure in the first place, the biggest question that arises is whether the parliamentarian is acting in faithful discharge of his duties. But if you leave that aside, okay, let us say he is faithfully discharging the duty. The second question arises whether he can change the basic structure because he has already taken an oath to protect, preserve and defend the constitution. This is highly arguable. I could say that having taken the oath to preserve the constitution, he cannot knock down the basic structure of the constitution. But one could equally argue because he is still faithfully discharging the duty, so that should not be caught under is third part of a third aspect of the oath. So I think this is a very arguable thing. There's no this or that answer to it, and people are about to have difference in opinion. Okay.
Just asking, simply asking.
Okay, I think the Indira Gandhi case, the federal court went into basic structure jurisprudence on whether 121, 1A, some sort of touch on whether the amendment was constitutional. But I think it was a judicial review application, and even without that, there could be many other grounds where they could have come to the same decision. In fact, I have written an article on Indira Gandhi decision that is available and it was published in London by Commonwealth Lawyers Association. I suppose it should be available on their website. I dealt with those things, and in fact, of course, the federal court could have reached the same conclusion without having to resort to basic structure. But I would feel that federal court took an opportunity to deal with basic structure in that case. It could be obiter or it could be ratio. I think that is highly arguable. Yeah. In fact, in my own article, I said that would not be necessary. So that would say, no, it could be obiter also. But whichever it is, I think whether it's obiter or ratio, I would stand by that the basic structure could be important in the form of constitutional world jurisprudence.
Thank you, Mr. Ahmad. So that is why lawyers have subjective questions. You don't answer A and B, it can be either A, B, or in between. Okay, the time is already up. We have reached 12:30, and I think before I would like to thank.
I'm just trying to say to brothers and sisters, you remember, right? Remember one thing, the world is changing. We are experiencing changing times. So everything needs changes, including constitution. I tell you, the one thing that cannot be amended at all, Quran. That's all.
Thank you, Dr. Sri Raja. So that's, I think, basically concludes our discussion. But I think taking into account the idea of digital activism, I would like to also take into consideration moderated activism. So whereby I'm going to go beyond the duty that I have. We are talking about the doctrine of basic structure. At the same time, we have to understand that we are a democracy. In a democracy, we elect our representatives who shall make the law. And what is the law? That is decided by the people's representative. And when we give power to the parliament to make laws, as well as to change the constitution, it is basically the people who speaks. So, having this in mind, some people are quite skeptic or have rather cautious about judicial activism. Judicial activism is good, but what is not good is judicial hyperactivism, where judges go beyond what they are entrusted to do. And doctrine of basic structure only exists in India. It only exists in India. It does not exist in other countries. So whether Malaysia would like to follow this doctrine created by Indian Supreme Court or what, it is up for the Malaysian. Okay? At the same time, no other countries have or apply such doctrine. So if Malaysia would like to be like India, then of course, I think maybe that's what we should think. But all other countries have constitutions and their parliament can change their constitution. As including America, and of course, UK has parliamentary supremacy. As well as, and I think I would like to conclude as what Dr. Sri has mentioned, the constitution is not a religious scripture revealed by God. It is man-made law. And if it is man-made law, then men have to adopt to changes and circumstances. By that, I end our discussion and thank you very much.